A very good evening to all. NMO Andhra Pradesh proudly presents the legal scalpel sharp insights for doctors by the bench. In an era where medical practice is increasingly intertwined with legal responsibilities, understanding the medical legal framework is essential for every healthcare professional. It is a matter of great honor and privilege for NMO Andhra Pradesh to welcome a esteemed speaker for today's session. Before we invite him to address us, it is my privilege to introduce our guest, Honorable Sri Justice Harinath Nunepally, sir, whose remarkable journey in the field of law and justice has been an inspiration to many.
నిమిషం ఒకసారి వాయిస్ రీచెక్ చేసుకో.
క్లారిటీ ఉందా సార్?
బ్రేకప్ అవుతుంది, బ్రేక్అవుట్.
ఓకేనా సార్?
కొద్దిగా వాయిస్ లౌడ్, వాయిస్ కూడా పెంచుతాం సార్. క్యారీ ఆన్.
Sir, born on 12th January 1972 at Kurnool. Completed schooling and intermediate education at Hyderabad. The legal education pursued the 5th year integrated law course at C.R. Reddy Law College of Elur. He was enrolled with the Bar Council of Andhra Pradesh, marking the formal start of his legal career at 1994 of November 30th. Commenced practice in the chambers of Senior Advocate Mr. Ravi S. in the High Court of Andhra Pradesh. Sir also served the Government of India before the High Court of Andhra Pradesh at the time period of 2001 to 2004. As a senior panel counsel at the year of 2004 for the Government of India at the High Court, Hyderabad. The Directorate of Enforcement at the year of 2011. Pursued services as a special public prosecutor for the NIA, Government of India. Member of Bar Council of Andhra Pradesh at the 2012. At the 2016, he re-empaneled Senior Panel Counsel at the High Court of Hyderabad. He became the member of Bar Council of Telangana at the 2018. 2020, engaged as ASG for Andhra Pradesh High Court. Redesignated as Deputy Solicitor General of India for the AP High Court. He holds with distinction at the 2022 September 13. He also an advisor to national and multinational companies. He also an additional judge at the year of 2023, October 21st, of the High Court of Andhra Pradesh, Amravati. He became permanent judge at the year of 2025, August 13th, of the High Court of Andhra Pradesh. It is our privilege to welcome Honorable Justice Harinath, sir, to the Legal Scalpel webinar series.
Thank you.
Towards you, sir.
Yes. Thank you and good evening to all the Vaidyo Narayano Haris. We will start the session with a small prayer. Sharire Jharjara Bhute Vyadigraste Kalebare Aushadam Jahnovityam Vaidyo Narayano Hari. Now this prayer, this sloka relates to the faith a patient has in the medicine and the administrator of medicine who is compared to Lord Narayana himself. The concept of God acting as the ultimate healer is very Vedic. And in Rig Veda, the divine Rudra is prayed as the first divine physician. Now, with this background, you people have chosen the most noble profession in the world. You have the ability to save lives. And any patient who approaches a doctor who saves his life, not only for the patient, but also for the entire family, the doctor is equivalent to the God. But are all doctors now considered on par with God himself? The answer appears to be a strong no. Now we'll divide this session into two parts. A general topic as to what is instigating the patients to resort to violence in the hospitals or clinics and even outside the premises of the hospitals where doctors are spotted. Now, this violence against the healthcare workers is a recent trend. Recent means maybe around 20-25 years it started off. Prior to that, there was no major incident of attacks on the doctors. Now, this trend has multifolded after the COVID pandemic. This trend of attacking doctors is not confined to our country. Even the most advanced country like USA, they have their own set of problems. And if you search the web, you will get to know as to what is the incidence of attacks on the medical professionals in United States also. Though a country which is considered to be very advanced, sophisticated, what you call research methodology is available there, and state-of-art apparatus, equipment is available, still the doctors are vulnerable and the medical professionals are vulnerable even in United States of America. Now, the single biggest problem which can be identified as the reason for attack on doctors is lack of communication. George Bernard Shaw once he said, the single biggest problem in communication is the illusion that it has taken place. So, my dear doctors, the trigger points which are identified for violence against doctors are sudden and unexpected death of a patient, and the family had no prior intimation of the severity of the procedure which is being taken upon the patient. At times, indifference attitude of the medical staff. Patients' attendants feel that they are kept in dark, they are not aware as to what treatment is given, what is the condition of the patient. And with the advent of the private hospitals, we have seen instances of exorbitant billing. Now, this has given rise to the suspicion of financial exploitation by the hospital staff, and they feel that doctors are part of it. The language barriers between the patient attendants and the doctors. Swami Vivekananda, in one of his speeches, he said, try and communicate in the local dialect, the language which is understood by the other side person. That should be applicable even to doctors. When a patient approaches you and you do some procedure on him, thereafter, you start to explain the situation in complete medical terms to the attendants who might be literate, semi-literate, or illiterate. For them, whatever is communicated is Greek and Latin. So the best option would be to communicate to the patient and the attendants clearly in vivid, unambiguous terms as to what is going on with the patient and what is being done. Now, communication must begin at the point of admission only, not after the crisis. When the patient is received in a serious condition, maybe he comes to the emergency ward, the doctor or the designated team of medical professionals who are there must explain the critical condition of the patient in plain language. For example, an accident patient is brought to the hospital in the emergency ward and he has a head injury. Patient is unconscious. Now we need to explain to the patient's attendants that unless and until a CT is done, we would not get to know the grievousness of the injury. Now, after the CT is done, the way he is responding to treatment, all that has to be explained to the patient attendants. Indicate the range of possibilities of outcomes very honestly, including worst scenarios. Identify a primary contact person in the family for all updates. You need not answer each and every person who is coming to the hospital just to see how the patient is doing in the hospital. Identify one person and then talk to him. Now, doctors also need to schedule a period of periodic briefings, even if there is no change. For example, there's a patient in the ICU and the patient needs to be in the ICU for the next, say, 36 hours or 60 hours. Then periodically, somebody should be communicating with the identified contact, informing as to the patient is doing good or vitals are normal, or if the patient has deteriorated, inform that this has come down or that has gone up, and we are trying our best to ensure that normalcy is restored. Now, this use of technical terminology would create a barrier between the understanding capacity of the attendants and the doctors. For example, you say multi-organ dysfunction with septic shock and poor prognosis. The family hears this. Instead of that, you can say your brother or your son or your father, whoever is the patient, so his kidneys, liver and lungs are all under severe stress at the same time.
Sir, sorry to interrupt. Sir. Just
despite our best efforts, his body is struggling to respond. We are doing everything possible, but you must be prepared for everything. This is simple language which is understood by everybody. Now, when the family is grieving, the doctors who are attending would have to empathize with the patient's attendants and reassure them. Reassurance does not mean giving false promises. Reassurance is, yes, this has gone wrong, and they will also understand things are not well, things are not going in the way they expected. And a honest prognosis without false hope is what is required. Normally, we get to hear from the doctors say, sab theek ho jayega, don't worry. Anta manchiga undandi, baane undandi, baane undandi. I think that answer comes from the doctors when they don't have the first-hand information as to what is the present condition of the patient. Instead of that, be informed as to the condition of the patient, then only speak to the attendants as to what exactly the situation. And as it is already said that honesty, uncertainty is always better than dishonest certainty. We are doing everything we can, but the situation is very serious. We cannot guarantee the outcome, but this sort of information is both truthful as well as compassionate. The patient understands, yes, doctors are struggling. The night doctors are struggling. The night duty doctors are struggling, and they are doing their best. So, I mean, it's all in the hands of the God, the Almighty, who created you. So this sort of thing should be there. Now, informing before the crisis and not after the crisis is very important. Doctors, please be informed on this. Stage 1 is patient is stable but under observation. This is the first.
Excuse me, sir.
Yes.
Sir, sorry to interrupt. Sir, your video is off, sir.
Yeah,
The audience are asking.
No problem. Yeah. See what we can. Hope
Yes, sir. The audience are asking. Keep on asking for you.
I thought because none of them were on, so I switched on. Switched off.
Sir, it's a webinar, sir, so it will be visible to you, sir.
Okay,
sir, one more thing. What about the PPT, sir? When should we share the PPT?
I'm going to start the PPT.
Yes. You will short by yours. Focus. Just 2 things. Thank you, sir. You can continue.
Now, stage 1 is patient is stable but under observation. This is one step what we can say. The second step is condition has worsened. We are escalating the treatment. And third stage would be patient is critical. Next 12 to 24 hours would be crucial. Then stage 4, we have exhausted all options. Please come immediately. If this stage of information is shared with the attendants, then the attendants also will be prepared for the eventual result of the patient. Now, the legal framework in India is there in so far as protection of doctors is concerned. I'll come to that a little later. Now, coming to the PPT, I'll just share that. Yes, can somebody share the PPT which I shared?
Yes, sir, we'll be sharing.
Yeah.
Namisha, can you share?
Okay.
I switched on the PPT on my other system.
It will happen. Namisha, నీకు అవ్వకపోతే నేను చేస్తాను.
సార్ అవుతుంది.
సరే.
Sir, is it visible, sir?
Yeah, it's visible.
Full screen.
Yeah, I think you can go for full screen, madam, because the words may not be visible to everyone. Legibility.
Sir, full screen.
Full screen. Enable. Click on enable editing and click on the cup and saucer.
Is it okay, sir?
ఆఫ్ అయిపోయింది. ఒకసారి మళ్ళీ రీషేర్ అవ్వండి.
ఓకే సార్. ఓకే సార్. Sir, is it visible, sir?
It's
Yes,
visible. Yes.
Go to next slide.
Go to the next slide, Amma. Yes. Now this Indian Medical Association versus VP Shanta. This is a case where the Supreme Court defined the medical services as consumer and brought within the purview of the Consumer Protection Act 1986 the services rendered by the medical professionals. Now, Supreme Court has been very categorical in its definition of consumer and the services rendered by the doctor coming under Consumer Protection Act. So all paid services, non-government hospitals and private clinics which charge patients, they are covered under the Consumer Protection Act. Now some mixed services, like some hospitals charge the affluent patients but treat poor patients for free, they are also covered under the Consumer Protection Act. Government hospitals and government doctors, dispensaries, where 100% free service is there, they're not covered under the Consumer Protection Act. Now the legal reasoning distinguish between contract of service and contract for services. The professional services are included under contract for services. Now, Supreme Court rejected the arguments that medical professionals are outside consumer law due to their professional status. It clarified that negligence standards for doctors remain the same as in tort law, TORT. Ordinary skill and reasonable care is expected. Now, patients have been brought under the purview of consumer in this landmark judgment of the Honorable Supreme Court. Now, go to the next slide, Amma. Next slide, please. No, the slide above one. One slide above. Go back to the next earlier slide. Yes. Yeah, this one. Dr. Suresh Gupta, the second slide, third slide. Anyway, for some reason the third slide hasn't come, but it's another judgment of the Honorable Supreme Court where Dr. Suresh Gupta versus Government of National Capital Territory of Delhi, where gross negligence was defined. Now, the law established by the Honorable Supreme Court is that to convict a doctor criminally, the negligence must be gross. Standard civil negligence is insufficient to expose a medical professional to the risk of prison, as it would destroy the mutual trust between a doctor and patient. So in simpler words, to convict a doctor and imprison a doctor for negligence, the standard of negligence has to be proved. And the gross lack of competence would come under the culpability of the criminal liability, wanton indifference and recklessness. Then this is the top thing which comes under the criminal liability. If the doctor exhibits, if though he doesn't has the competence of conducting a surgery on a patient, and the wanton indifference, probably for whatever be the reason, and recklessness, these come under the purview of criminal liability. Now, probably inadvertence, want of adequate care, they come under the civil liability. No error in judgment or accident, no liability at all. Now, the fourth slide to distinguish between a civil and criminal liability of medical negligence is, now let's go to the fourth slide, madam. Fine. Fourth slide is like this. Now, burden of proof. In a civil law or a Consumer Protection Act, the preponderance of probabilities is there. But in a criminal law, proof beyond all reasonable doubts. Now, for civil law, degree of negligence is simple and lack of ordinary care. In a criminal law, very high degree of gross negligence has to be proved before the court of law. Now, what is mens rea is a intention. Mens rea is guilty mind, basically. Now, civil law doesn't require a mens rea, but criminal law requires a mens rea. Mens rea, to explain in a simple term, a doctor performing an eye surgery, and for some reason, instead of doing it to the right eye, he does it to the left eye. And later on, it comes to know that it was done deliberately on instructions of somebody. So it's a very high degree of gross negligence. Now, and strict mens rea, because he had the intention of doing it. Now, legal consequences in a civil law are damages and financial compensation. In a criminal law, it is imprisonment. Now, come to the sixth slide. This is one more judgment of the Honorable Supreme Court. Jacob Matthew versus State of Punjab, defining the standard of medical care. Now, there's something called Bolam test. In this judgment, the Honorable Supreme Court adopted the Bolam test. A doctor is not negligent if they act in accordance with an accepted practice of responsible body of medical men, even if better alternative existed. So, what is Bolam test? It is in a celebrated and very often cited decision, Bolam versus Freen Hospital Management Committee, Queen's Bench Division, that's a UK judgment. It was observed that a doctor is not negligent if he is acting in accordance with the acceptable norms of practice. The test so laid down properly came to be known as Bolam's test and stands approved by the Supreme Court in Jacob Matthews for State of Punjab and another. In this case, a patient died in the hospital ward after an oxygen cylinder was found empty and immediate replacement was unavailable. Then the Supreme Court has deployed the Bolam test and found that the doctor is not liable in such cases. Yes, Bolam test evaluator is over. Now, yes. Basically, the Bolam test evaluator is like this. If the professional is negligent, the Supreme Court applies the standard of the ordinary competent man exercising the particular act. Did the professional possess requisite skill they profess to have? If answer is no, it amounts to negligence. If the answer is yes, go to the next point. Did they exercise that skill with reasonable competence in the given case? If it is no, it amounts to negligence. If it is yes, go to the third block. Is the chosen course of action acceptable to the responsible body of medical professional? If the answer is yes, there is no negligence. And one more thing, a doctor is not negligent merely because an alternative course of treatment is available or because a more skilled doctor would have chosen a different practice. So this doesn't come under medical negligence. Now coming to the medical consent. Eighth slide, Amma. Yes. This is a Samira Kohli ruling where legal requirements and boundaries of patient consent in India. This was established by the Supreme Court in the judgment from doctor-centric to patient-centric decision-making. Now, consent must be real and informed. Duty to disclose is on the doctors. They must explain the nature, purpose, benefits, alternatives, and substantial risk involved in the treatment. Once again, the Bolam test standard. Diagnostics versus therapeutic consent. Consent for a diagnostic test does not authorize additional therapeutic or radical surgery. So both consents are different. For example, a patient has to undergo a CT scan. You take a consent. Then after the CT scan, there appears to be some block in whatever, probably it could be in the leg or where surgery is required. For that, you have to take a separate consent. Now, emergency exception. Unauthorized surgery is only permitted to save life or preserve health in emergencies. Yes, but that's also coming up with a risk. Limits of convenience. Saving the patient time or money is not a valid defense for unauthorized surgery. Now, this column test is United Kingdom, and Canterbury test is in United States. Real consent in India. Now come to the next slide. Now, this is one more important judgment of the Honorable Supreme Court. V. Kishan Rao versus Nikhil Super Speciality. When the thing speaks for itself. A patient presenting with intermittent fever and chills was wrongly treated for typhoid. Upon critical deterioration, another hospital's tests confirmed malaria and patient died. Now, is a medical expert opinion required for such cases? In complicated cases of surgery, yes, expert evidence is required. In obvious negligence like malaria, treating malaria as typhoid or removing the wrong limb or wrong eye, then the act itself speaks. So you don't require a medical expert opinion. There are several cases which I also handled. Unfortunately, instead of operating to the right eye, the operation was done to the left eye. Though there was marking done to the right eye, for whatever be the reason, the doctor conducted an operation on the left eye. Thereby, the patient became completely blind. In such cases, what defense do we have? We don't have any defense at all. I mean, the action speaks. I mean, the act speaks for itself. So, overruling the in D'Souza judgment, the earlier law was like this: in all cases of medical negligence, expert opinion was required. But after this V. Kishan Rao judgment, the Supreme Court said this expert opinion is not required in every single case of medical negligence. This is against the doctors, but yes, I mean, it is law is like that. I mean, we have to live with it. We'll go to the next slide. Slide number 10. Yes, madam, can you display the slide, please?
Yes, sir. Slide number. The slide. Is it the slide, sir?
After Kishan Rao.
Yes, sir. Balram Prasad versus Kunal.
Correct. Now, this judgment is based on the child psychologist tragic death of Anuradha Shah, very famous child psychologist, from toxic epidermal necrosis 10 due to gross overdose of depomedrol steroids. Now, normally for compensation, which is granted to the victim's family, in motor vehicle cases is completely different. They have a multiplier method over there. The multiplier method will include will consider the age of the deceased or age of the injured, the earning capacity of the injured or deceased, and what could be his earnings if he survived for the, say for example, a 40-year-old person met with an accident and lost both the limbs. So he became completely incapacitated. In such cases, and assuming he was working as a bank clerk, he was earning around 40,000 per month. So there's a multiplier system in the Motor Vehicle Act cases. Now that is not there in that is not followed in medical negligence cases. In medical negligence cases, it all depends on the standard of living and the inflation over the next 15 years or whatever be the lifespan of the victim. A victim's income is considered and future prospects would be considered. And the compensation which is arrived at by the courts is completely different insofar as medical negligence cases are concerned. So let's go to the next slide, please. Now there's a shift from the patient accountability to provider security. From 1995 to 2013, the era of accountability was there. Focus was there. Negligence and consumer protection law, 1986, the Consumer Protection Act, compensation, all these things. The consumer courts were flooded with a lot of things. I myself, as an advocate, I handled one case of a dental surgeon. The lady was from, I think, Sudan or something like that. Yeah, I think Sudan. They came to India for a treatment of, I think, root canal or something. They came to me with a complaint saying that the doctor has not treated them properly and severe pain and all that. I referred them to some other doctor. Then that doctor said, what should have been done in a specified manner was not done. And instead of that, this is done like this, so we can't rectify it. You have to go back to the doctor who has performed the implant. Then this lady went there, and then there was some complication. Ultimately, a case was filed, and there was a reputed hospital in Hyderabad. Then ultimately, things came down for a settlement instead of going for a full-fledged litigation. The doctor was wise enough. Then he came forward and then said, yes, I mean, if that be the case, let me close the issue. Fortunately, this lady accepted what was offered and then that was closed. So the compensation, it all depends on the degree of pain suffered by the patient and the manner in which the patient would respond. Now, coming to the strained and unprecedented pressure on the doctors during the COVID pandemic. The Supreme Court has now shifted the focus. The pendulum has swung the other way. The primary legal question evolved from how to hold doctors accountable to how to keep them alive. So this is a very good development insofar as the change in law or the perception of the medical professionals is concerned. 2020 is called the era of vulnerability. All hospitals during the pandemic period were completely overcrowded. There was a lot of pandemic stress, physical assaults, systematic failures. I mean, oxygen deficiency was there, so on and so forth. Yes, let's go to the next slide, please. Asif Iqbal versus State of Assam, the pandemic wake-up call. During the height of COVID-19 pandemic, a wave of physical assaults targeted doctors, nurses, medical staff by panicked or grieving public members. Now, the Holistic Safety Shield was mandated by the Guwahati High Court by the state government. It moved beyond post facto compensation for victimized doctors to demanding preemptive, adequate safety measures, and prompt state action to protect frontline medical workers discharging their duties in high stress environments. This is a very good thing which has happened, and almost all states have followed. Yes, next slide, please. Now, in that Guwahati case, the medical staff who were assaulted by the relatives of a COVID-19 patient who succumbed to the virus, immediate action was taken by the state 32 persons were charged and subsequently they were also convicted. The trial was expedited. Now, in a fast track mode, it was done in 60 days. The general perception that once a matter ends up in court, it might take ages has been proved wrong, because a fast track trial was directed and it was completed. Now, what mandatory hospital safety protocols are required? Now, surveillance, 24/7 surveillance by CCTVs is essential. And this was mandated by the Guwahati High Court, that continuous CCTV monitoring in all state-run hospitals, nursing homes, and centers, other medical centers, basically. Weapon-free healthcare zones. General public were strictly prohibited from carrying any sorts of weapons or firearms inside the healthcare institutions. And mandatory warning signage. Hospitals must display boards detailing legal penalties for violence, and local police contact information was predominantly displayed in the hospital in wherever people were likely to assemble. Now, protection measures and legal basis. Toll-free reporting. A new dedicated hotline for reporting violence against medical staff was mandated. Then Assam Medicare Service Persons and Medicare Service Institutions Act 2011 was drafted. Then victim compensation. Affected staff may apply for compensation through competent legal authority. This was a step taken by the Guwahati High Court in view of the attacks on doctors in the state of Assam. Let's go to the next slide, please. Now, this is a very interesting case. Neeraj Sood versus Jaswinder Singh, 2024 case. The ptosis drooping eyelid surgery resulted in the patient's vision deteriorating from 6/9 to 6/18. The National Consumer Disputes Redressal Commission assumed negligence based purely on the deterioration, but Supreme Court reversed this. Why? The rule of res ipsa loquitur, the thing speaks for itself. The general known myth is a failed surgery or adverse reaction proves negligence. That's a myth. Reality is the thing speaks for itself. If any application in criminal medical negligence, it cannot be applied straight away just because the patient did not respond favorably. So, deterioration of a patient post-surgery is not necessarily indicative of inappropriate treatment. Human bodies are complex machines, and sheer chance plays a role in medical outcomes. Now, that myth has been clearly taken note of by the Supreme Court, and the judgment of the National Consumer Dispute Redressal Commission was reversed. Let's go to the next slide. Next slide. Yeah, this is a very important slide. After the RG Kar Hospital incident in Calcutta, Supreme Court took sumo to mandating systematic institutional security. Now, what is the infrastructure which is mandated? NTF. National Task Force was constituted, and Task Force gave some directives. And what is mandated? As doctors, you should ensure that the National Task Force directives are implemented in the state of Andhra Pradesh. Now, it's upon you to take care of all this. Now, first thing is infrastructure. Mandating separate duty rooms for male/female staff, secure resting spaces, and commensurate police outposts based on hospital footfall. Depending on the number of people who come to the hospital, visitors coming and going, the adequate police post should be available. Now, Posh Act enforcement. Strict application of the Sexual Harassment of Women at Workplace Act 2013 to all hospitals, mandating Internal Complaints Committee. Now emergency systems. 24/7 emergency distress helplines specifically for medical professionals is mandated. I am not sure as to how far the directives of the National Task Force are implemented in the various hospitals where the doctors are working. Please ensure that this is displayed in your hospital, and the persons who are competent enough to administer the competent enough and administering the hospitals should ensure that the infrastructure is in place. Yes, next slide. Next slide speaks about the current state of medical dash legal equilibrium. What are patients' rights? Protection from gross negligence, Suresh Gupta case. Access to consumer courts, Shanta case. Holistic financial restitution, Balram Prasad case. What are medical professionals' rights? Protection from frivolous arrests, Jacob Matthew case. Defense via the Bolam test. Mandated physical and sexual safety in workplace 2024, Sumoto, NTF. Now, Indian medical jurisprudence has matured from a unilateral focus on penalizing malpractice into a dual mandate, ensuring the highest standard of care for patients while unconditionally guaranteeing the dignity, autonomy, and physical survival of the healers. Next. Let's go to a slide which speaks about the AP Medicare Services Act 2008. Protecting those who heal. Understanding the AP Medicare Services Act 2008. Now, what is the scope of protection? Who are all protected? Under this act, the doctors, nurses, medical students, nursing students, and all employed and paralegal workers, they come under this act. They are covered under this act. And which all institutions are covered? This protection extends to all government, private, maternity, and nursing homes and facilities. So almost everything is covered. Now, what are the legal consequences and penalties? Any act of violence against a doctor or a medical staff under the relevant provisions of the act, imprisonment up to 3 years and fines. Fines up to 50,000 rupees. All offences under this act are cognizable and non-bailable. What do you mean by the word cognizable? Cognizable offence means nobody needs to give a formal complaint. The police, if they come to know, they have to immediately take action. So they can immediately come and then arrest a person who has committed an offence or an act of violence against the medical staff or damage some property of the hospital. The police can straight away come and pick him up. Now, any offenders who damage the property, the act provides for twice the purchase price of any medical equipment. Next slide. Yes. In case of negligence, death by negligence, under section 106 of the Bharatiya Nyaya Sanhita 2023. Now, if the death is caused by a registered medical practitioner while performing medical procedure, the maximum imprisonment is limited to 2 years plus fine. This is subject to proof of acute medical negligence in the court of law. Same section applies to hit and run cases also. This is causing a death by negligence under section 106 of BNS. In a hit and run case, the punishment extends up to 10 years. So see the difference. If a medical practitioner for some reason has committed a gross negligent act which resulted in death of a patient, then the medical professionals, the maximum punishment imposed is up to 2 years only. General negligence is up to 5 years. For example, somebody does a act of negligence. For example, somebody pushes somebody. It could be an act of negligence. Then there, the punishment is up to 5 years. So this is basically on the punishments under section 106 of BNS for for death by causing death by negligence. Now come to the next slide, the burden of proof slide. Next slide, please. Next slide. Burden of proof is the next slide. For some reason, it's not being displayed. It's like the stage 1 is the patient must prove duty of care which existed. Stage 2 is patient must prove breach of standard of care. Stage 3, patient must prove direct causal link between breach and injury. Now, protecting professional autonomy. Indian courts have consistently held that mere error in judgment or an adverse outcome is not negligence. Clear, credible evidence linking the doctor and the act which has happened to the patient's injury is essential. Frivolous litigation is increasingly filtered at the threshold. Courts acknowledge doctors as the second victim of malpractice claims. Expert medical opinion is often required to establish breach of that standard. So this is on the burden of proof. Now coming to the last slide. Last slide, madam. Last slide. It's important slide. Yes. Now, what are the key takeaways for the medical professionals? Document everything. Meticulous patient records are your primary legal defense. Document diagnosis, decisions, and consent discussions contemporarily. Communicate clearly. Informed consent is your strongest shield. Explain risks, alternatives, and expected outcomes, and document that conversation. Uphold standards. Adhering to professional ethics is not just a moral duty, it's a legal imperative that courts scrutinize closely. Always remember, the law does not demand perfection. It demands reasonable, competent, and well-documented care. So, doctors, that's it for now. And I think we are running short of time. Any questions are there? We can take the questions.
If there are any questions, please mention in the chat box. Sir, there is a question, sir.
Yes, madam.
Sir, can a doctor deny treatment? In the chat box, they ask us.
Yes, doctor has a right to deny treatment. There is no hard and fast rule that doctor has to treat. Assuming I go to a doctor with MBBS qualification and say that I'm not able to see properly in my right eye, he can always deny, saying that, I mean, this is not my what you call realm of treatment. You have to meet an ophthalmologist. That can be done. But denying treatment for what reason? That's also important. Denying treatment in critical cases, for example, a patient is brought in a very traumatic situation, and doctor always can deny treatment, saying that, I mean, the kind of equipment which is required for treating such kind of patient is not available. Please go to some other hospital. That can be done. There's no negligence on part of doctor in denying treatment.
Okay, sir. Sir, other question, sir. What is your opinion on criminalization of abortion in the US?
Of abortion in US. Yes, I think even Supreme Court has also mandated that abortion cannot be done beyond a particular point of time. So in several cases where unfortunate victims of rape and they get impregnated on account of that offense, and when they applied for abortion after a particular point of time, the courts also said no, because I mean that's dangerous even for the mother carrying the child. That's basically on the advice of the doctors only, because doctors also, as doctors, as to what is a safe point of time and what is a beyond a particular point of time, the abortion should not be done. So yes, I think that's right. What they have done is right.
Thank you, sir. Sir, other question. What's the ideal thing to be done immediately after our premises are attacked by attendants of the patient for whatever reason?
Yes, see, as already suggested, ensure that you have adequate security. For example, it's a government hospital, you need not worry about it, because the state police will be there. If it's a private hospital, ensure that you recruit proper security personnel, one. Number two, inform the nearest police station immediately, and the staff in the hospital should ensure that the doctor is not left alone in the attack. Somebody should come to the rescue of the doctor immediately, hold the people, and then shift the doctor to a safe place. Meanwhile, the other staff also should ensure that the situation doesn't escalate. Your security people step in, and then it should be restrained.
Okay, sir. Other question. Is it true that consumer courts are always favorable to the patients and against the doctors?
Not at all. The shift from accountability to protecting doctors has shifted from 2020 onwards, because every failed surgery was landing up in the consumer court. Every failed treatment was landing in the consumer court. So the courts have realized that doctors need not run around the courts uh, for facing frivolous complaints. As in one slide, the Supreme Court held that treatment of the same kind may not give the same result on all patients. The standard of treatment is the same, but the kind of recovery could differ from patient to patient. So keeping all this in view, that's a myth what you have stated, madam, that the consumer courts are meant for consumers and not for the respondents. Consumer courts are meant for true consumers, actual consumers, not for everybody who approach with false complaints.
Okay, sir. Other question is from Dr. Ravi Shankar, sir, HOD of Anesthesia, GMC Pidigrala. He is a NMO AP State President. Question
Okay.
is regarding non-medical professionals practice.
Non-medical professionals, I mean, like what? Can the doctor elaborate on this? Are you referring to RMPs practicing, or Ayurvedic treatments, or I mean, I'm not sure as to what the question was.
Regarding RMPs.
RMPs, right? See, unfortunately, in India, the RMP doctor who is there in the village is considered as the most efficient and the what do you call? I mean, he treats everything, right from could be a small injury to the leg to the even the heart attack also. So I mean that faith has developed because of lack of medical facilities in the rural areas. For that, that's one reason why the government has been insisting on the doctors working in the rural areas as well. Because if a proper trained doctor is available in a village, the patients don't go to an RMP. Strictly personally, from my my perspective is, yes, that should be curtailed, because these RMPs, they treat everybody for all ailments, and they have some sort of nexus between some corporate hospital sending patients there for treatment. That nexus should be cut down. For that, the doctors need to branch out, reach out to the rural areas. Then only this nexus will be cut from the umbilical cord.
Sir, sorry to interrupt you, sir. With your permission, can we share the some activities of the NMO videos?
And please share them, or you can share on my email ID, or if you want to share it, you can share it. We have got a very interesting logo. I've seen your logo. Dhanvantri is there in your logo. I was very impressed.
Yes, thank you, sir.
నిమిషం వస్తుందా?
Sir, please.
So it's a 2 minutes video, sir.
Yes.
For activity.
సరే చాలు శత సైన్యాలు నడిపే దేవుడైనా వసుధావాణి దిగిరామేని మరి పెట్టుక పలుకు పలుకులెరుగగలడా నీలి మేఘములను కరణి నయనాంజరంగములను జలధి జలము
So that represents a few of our activities which are increasing in coming years, sir. And the expansion has gone to almost all medical colleges, and we are trying to invite big people like you and other representations from the society, and we are bridging the gap between various specialties and the medical specialty by NMO, sir.
Very impressive.
Yes, sir. Namish, you can take over.
Thank you, sir, for your permission.
Yes, thank you so much, and God bless you all with a great future. Do good service to the country. That's what is expected from all of you. Thank you so much. Jai Hind.
Thank you, sir. Sir,
Thank you.
remaining questions will be answered.
Anything? Yes, madam. Anything is there? Please share it on my email ID. I'll respond probably after 2-3 days, because from Monday again our court starts. So whenever I get some leisure time, I'll respond to your emails. Any queries are there? Please send on my email, madam.
Okay, sir. We'll conclude with the Shanti Mantram, sir.
Yes. Very
Namish, please take.
Yes. Sarve bhavantu sukhinah, sarve santu niramaya, sarve bhadrani pashyantu, ma kaschid dukkha bhavet. Om Shanti Shanti Shanti. Thank you.
you.
Thank you.